Interesting briefing to a topic of great interest. What we'll do is I'll just get an introduction from Liam, who is the town planner, which is a very important title, and he's going to tell us about what we should focus on today's presentation. And then we'll hand it on to the presenters to actually provide the presentation.
Kia ora tātou, nau mai haere mai ki a tēnā hui. Thank you, Mr. Chairman. I'm not going to tell you what to focus on. What you need to do is to pay attention and focus on what you want to, and we're here to answer your questions. I've got the team here from the District Planning Unit, as well as our key barrister helping us, who'll introduce himself when his section comes. We also have the Independent Hearings Panel Chair, who will also introduce himself when he talks. Of course, this will be coordinated by Sean and Michael. But it's been a long, winding road. We're getting very, very close to concluding this piece of work. We'll take you through how far we've come shortly, and then explain what actually happens next. We do have some commentary around the roles of you as decision makers and the roles of the Minister as it relates to the fast-tracking ISPP process. We'll provide some detail in that regard as well. We'll also have some advice for you on how to interpret, if you like, some of the recommendations coming from the IHP and where it's going to go after you determine to recommend these amendments to the Minister. We'll also provide, finally, an update on resource management law generally. The system is in a great deal of flux with the incoming government, so we'll do our best to explain how some of these decisions before you, without any legislation change, may have to be interpreted going forward as well. I think that's me for now. I'll hand it over to Sean to commence the presentation.
Though, right? For all of that.
Yes,
okay,
I propose to be rather efficient.
Okay, well done.
So the first thing is this briefing is designed to inform you of the role you'll be taking up in making decisions on the district plan. There are some differences to the processes you are usually operating under the Local Government Act. There are also differences in the way you make amendments. So we won't be covering the content of the plan itself. What we'll be showing you is when you'll be receiving that content and how you'll be briefed ahead of your decisions in March next year, and the sources of expertise you can draw on in order to provision you for that meeting. What I'm going to run through is how we've got here, what happens next, your roles as decision makers, and the resource management system reform that is coming through with the new coalition government. Bear in mind, throughout this process, it's very much a learn alongside situation, as in I am learning alongside you, so I cannot provide you complete certainty over what the government will provide because I do not know. So where are we in the process? Oh, yes, Councillor Young, that's looking towards Karori. They are motes of light. I should have cleaned the lens. I will see to it in future. Very good. Many of you will remember that we began on this road with the Our City Tomorrow program back in 2017. I imagine Moana sitting behind me is triggered. We then went through the growth scenarios, the draft spatial plan, the finalisation of the spatial plan. What that did is effectively align the investment programs and the land use direction for the city over the next 30 years at a high level. What has then taken place is from the spatial plan we have drafted a non-statutory draft district plan, which was then considered by the council. It was submitted on. That draft district plan was incorporated with amendments to become the notified proposed district plan, which you notified in July last year. Since that plan left the council table, it has been submitted upon, and it has been through a hearings process run by the Independent Hearings panel that you appointed. The chair of that panel, Trevor Robinson, is with me today. The Planning for Growth program the Planning for Growth program has basically moved from that outcomes basis of agreeing what the future of the city should look like through Our City Tomorrow down to the level of drafting the rules which will help the city take that shape through that time frame. Throughout, there have been public engagements, and we are now at the point of considering the district plan, the first half of the district plan. Throughout this process, there has been regulatory change. There have been the introduction of national planning standards. So these have standardised the structure and formats of district plans. There has been the National Policy Statement on Urban Development, which has required intensification around centres. There have also been Resource Management Act changes, which have brought in medium density residential standards. So these changes have all been incorporated into the plan through these various steps. The council has also divided the district plan into two halves. What we are talking about today is the first half, the Intensification Streamline Planning Process, the ISPP. I've tried to keep the acronyms to a minimum. I can talk entirely in them if I'm left to my own devices. What this instrument has done is create a bespoke process for that first half of the district plan to go through, so it is different from the Schedule 1 process. The topics which have been allocated to that are on the left there, and they will be what is briefed to you in February and March next year. The diagram version of this shows where the processes are quite different, and that is largely when it comes to your latitude of accepting panel recommendations and then what happens to them. So effectively, under the ISPP, the one on the left, the council has the option of accepting a recommendation or not accepting a recommendation. If you do not accept the recommendation and provide an alternative recommendation, it will then go to the Minister for the Environment to take a final decision. That will then become operative, and it is without appeal to the Environment Court. It is important to understand that the ISPP still allows judicial review, so the form of your decision making can still be reviewed by the courts. Coming now to the proposed district plan, it was notified in July of 2022. There is an 8-week submission period and 497 submissions were received. Those that fell under the ISPP have then been considered by the commissioners during their hearings. We are presently working with the commissioners to receive their final recommendations for you, or their recommendations for you, and these are what will form the content of your workshops and briefings next year. Throughout the process, we have been involved with our mana whenua partners. This has taken place both in the development of the plan rules, through the ensuring that we have district plan commissioners with Mātauranga Māori experience, and it has resulted in significant advancement from the current district plan with respect to the recognition of mana whenua values and aspirations. So what happens next? What will occur is we will be receiving the Commissioner's recommendations by the end of this year. We'll then be working with those to put them into workshops that will go to councillors. One thing that will be important for you to manage as decision makers is the load of decision making you will have in the first part of next year. You will have me coming to you with the district plan, but you will also be doing your LTP deliberations. So these are both the largest and most complex instruments that council operates, and for the first time in our history they will coincide. You will then make decisions on the ISPP on the 15th of March. Any conflicts will then be immediately notified to the Minister for the Environment, and then we will await her decision. As soon as anything that has been accepted by the Council will become operative, anything that has been notified to the Minister will become operative once they have made their decisions. Then the Schedule 1 hearings will commence, and the Commissioners will consider the remainder of the district plan. The independent hearings panel is as above. The chair, like I say, is here to help you answer any questions of process you have. We won't be able to answer questions on the recommendations, i.e. the content of the plan, simply because those recommendations haven't been received in their final form as yet. We will also be coming to you with a paper later in the week for the appointment of a replacement commissioner for Commissioner Faulkner. And you'll be considering that at your committee meeting, I think on Thursday. The hearings have been conducted in 6 hearing streams. There has been in total 36 days of hearings, and 144 submitters have been heard. There has been quite a number of experts that have presented evidence, and then those experts have also caucused to come to the recommendations that the commissioners will then put forward. All of these are available on the live streams on YouTube, should you wish to watch them. The text of the submissions is also available to you. So we come to the briefings. Apologies, this is quite small, but you have this through your diligence system. So next February, we will begin with a briefing where we just recap the immediate process you'll be in, so we won't do any of the history again. You've had that now. We will again make sure that your parameters are covered off, and any questions you've had between now and then, we can work with you and the lawyers to make sure that we've come to an answer for you, and that answer has been communicated to all councillors. We'll then begin to move into the briefings that are the substantive content of the district plan. So what you'll have there are the walking catchments, the questions about MRT lines, the high-level plan direction. You'll then move through into the residential chapters, which are one of the largest parts of the plan. They contain things like extensive character precincts, building heights, design guides. You'll then follow that with, I feel like a waiter reading a menu. The central city zones and the design standards, followed by the heritage portions of the plan, then the how we deal with natural hazards, the 3 waters section, and finally we will round out with a question and answer session. Now, it's important to understand how the dynamic of this briefing works, and that it's effectively like sculpting. So in the first plan, you'll get the high-level block of marble you're working with, and then it will be chipped away at. So these other controls will come in and influence those zoning patterns. So what that means, for example, is you might have a 30-metre height limit in a given zone, but then there may be a character control or something else that then changes it. And so that's why that last session has been put in before the meeting, so that you can then we can answer any questions in the aggregate you have. We'll then move to the council decision in March, and that's where the final decisions will be taken. The way we are planning to run these briefings is we will distribute the IHP recommendations to councillors in advance. You'll then have your workshop. After the workshop, we will publish those recommendations to the public, and then we'll go into working with you on amendments. The reason for having a slightly different amendment process this time is because of the way any amendments go forward into ministerial decision making. So an amendment in the law is called a creation of conflict. What that means is that you need to give us precisely what you want the rule to say if you are going to amend it. So we need the exact wording, and it has to work in a planning sense, and we also need to work through any consequential amendments that take place. District plans, the easiest way to think of a district plan is imagine I have tied my coffee cup with wool to every single thing in this room, and then I move it. Other things will move too. Some of them, like this carafe, I can see going to hit me in the face. I'm probably not going to anticipate Councillor Abdurrahman's cell phone whacking me in the side of the head. That's why we need to go through that kind of process, so that you have a coherent planning framework that can then be implemented by the consenting system. The other thing that will need to go forward with any amendment is an evidence base for that to the Minister. We would like to work with any councillor proposing an amendment to make sure that that evidence base is effectively packaged to that amendment, so that I'm not sending officers to backfill that in the 2 days or 3 days we have to get it to the Minister, but also so that the mover of the amendment is very clear of what their reasoning is, and that can go forward to the Minister in an agreed form. The Minister for the Environment is Penny Simmons. There's a picture of her. What the Minister will do is they will then work through that package of amendments and reasoning, and they will come to a decision. They'll then gazette that decision, and that will become the operative district plan. Now we come to the public, before we go into any public excluded comment for just a little while you receive advice from the lawyers, are there any questions?
All right, yes, I have some. So, first of all, the issue of judicial review, does that apply to the whole process coming to this point, or...?
Judicial review is always possible with your decision making.
But it applies to the spatial plan and the district plan decisions as well as this decision, or not?
Technically, yes.
Okay. And I guess my other question is about the way the independent hearing panel's recommendations will be made public and our kind of workshops. So does that mean, so they won't all be released at once prior to the workshop, or so they'll be released post the workshop? Does that mean each workshop will be public excluded?
No, we have tried to keep public exclusion to an absolute minimum. The only reason there is a portion here is because of the legal content. It is normal that in most councils, the whole process would be publicly excluded until they were compiled in a single document for you to consider. Rather than do that, what we are proposing to do is to release them at the conclusion of each workshop. So if your workshop concludes at 2 o'clock, we'll release it probably at 10 minutes past 2. The reason for not releasing them all at once is because we're dealing with constricted timeframes, there may be the last little bits of process for some of the ones at the end that had been done at the beginning briefing.
It does leave us in a position, though, where we are not looking at the entirety of the recommendations, which seems to me problematic as a governor, that I would be looking at bits of the pie rather than the whole pie.
You will have the whole pie by the time of the second to last briefing. I know this isn't ideal, however, I only received a 4-month extension for the ISPP process. So
that was my fault. So I guess that does, I do want to provide the feedback that does seem somewhat problematic to me as a governor, that I can't look at the entirety of the package of recommendations.
So what I will do is, once we understand a little bit later the precise dates we're receiving recommendations, and also what the workload is associated with those, we may be able to look at amending that. But just where I am at the moment, I'm a little bit. I am slightly concerned about releasing everything on the first workshop, given I'm not quite sure that I'll have it.
And as you say, your decision.
However, it wasn't when we made the amendment to, it wasn't predicated on that we would be drip fed the recommendations. That wasn't part of the advice.
Yeah, we'll see what we can do to bring it to you.
I just want to. I want to
as early
raise.
as
I think it's
possible.
problematic.
Yeah, and get it to you as soon as you can.
I
but
acknowledge that we didn't go into that level of detail when you made that decision.
Thank you.
You're going to come to future government things a bit later on, aren't you?
I am.
Okay, I'll save two of those for then. Just you're talking about how the framework for the amendments needs to be really coherent. Is that just in the ministerial process? Like I think of the infamous 1am Foster amendment you guys had at your district plan meeting that you were debating on the day. So that was okay in that process to work with, but you couldn't do that when it goes to the minister?
I make no judgment on the conduct of councillors, but the difficulty with this process is its finality. Dealing with amendments earlier in the process, there was an opportunity to take investigative amendments. So, for example, you had us investigate affordable and inclusionary zoning. There was an opportunity in further stages to deal with the technicalities of drafting. We are past that now. Your decisions will be final, and it is beholden on you to provide the best advice you can to the minister, given that you are conversant with the intricacies of the government of the city, and that is not their remit.
So I'm not sure if this is a Dem Services question, but if someone did try to bring amendments at a state, let's say the day before our final decisions, would that be ruled out of order? It seems like we have to have some kind of guards or protections here so that we're putting a coherent case to the government.
That would be a Dem Services question, which I'll have to get an answer to.
Yep.
What I'm suggesting to you is a process that would provide you with the best possible position. As with all of my advice, it is ultimately up to you as decision makers what you do.
Thank you.
Great, thank you. I have three questions. The first question was, earlier on you said that, you said on the slide that there's no appeals to the Environment Court. Is that appealing against the decisions that we make from the ISSP, is it? And so by whom would that be?
Yes, so those are the decisions only under the ISPP process. The law was drafted that way to extinguish appeal rights. The people who would take appeals would normally be somebody who didn't receive the outcome that they were interested in. So they were interested in more zoning or less zoning.
I see. Okay, that's good. Now, the changes that are going to be implemented because of the change in the government and the new government's policy, where do they get discussed at a later stage, or do we?
We'll come on to that.
Okay. Yep. Great. Okay. In that case, the two questions I have are in there. Oh no, actually, one more question regarding the new district plan, which is what we're working on. I find that the current district plan, or the operative district plan, has lots of leeway in it, so that because it's been in force for so long that the planners have actually said that, well, things have actually changed from there. So, for example, the operative district plan states that you can have 2 dwellings on one site as a matter of right, but in fact people were actually going out there and building 4, and so we're saying that the reason is because we want more housing, and so that is allowed. But that should be a departure from the district plan. So with the new district plan, are we going to have any exclusions, or are we going to have this leeway for interpreting it, or is it going to be absolutely rock solid?
So to take the example of, say, the district plan has a permitted activity of, say, 2 houses, but you're getting 4, that is what resource consent is. Resource consent is essentially the permission to move beyond the stated position in the plan, and that is why you have graduations of discretionary, restricted discretionary, etc. That basically is what determines that flexibility. The thing you have to also bear in mind at the present time is the consenting planners must also consider the proposed district plan, as parts of that bear different legal weights. And so there are certain parts of the proposed district plan that, when notified, received immediate legal effect.
I think, Sean, just given time, and we have a question online, Ray, I think after the session, if you wanted to sit down, Sean can explain in more intricate detail the consenting process, that would be more appropriate, so we can move on with questions. Thank you.
We'll just do Tony and then we'll go to Laurie.
Okay, I just wanted to understand a bit about what information we will receive when we receive Commissioner's recommendations, because there's, I think for me, I'm wanting to see what's different between the current district plan, the final draft district plan, and what the office has recommended for the proposed district plan versus what commissioners have recommended. Those are three things I think that are important to understand. And so in terms of understanding on the basis that really the key things we want to focus on are the things that have changed as opposed to the things that have stayed the same, I just wanted to know how much information we'll be getting to highlight that.
So normally what you'll received is a recommendations report that will have the recommendations of the commissioners and the reasons and which submissions they've taken up. You'll see how that interplays in the next portion of the briefing. We haven't yet decided the final form of the briefings you're going to receive. So I'll have to just have a bit of a think about whether it's manageable to do operative versus draft versus proposed versus commissioner decision.
Yeah, I mean, for me, the key one is between the draft. I mean, given that people who are engaged with this publicly, the last public view they really had feedback on, the one that was put through the council was the draft district plan.
That's not correct. The council voted on the proposed district plan and people have submitted on the proposed district plan. So yes, they have also engaged in the draft district plan, but the draft district plan and those submissions are ultimately what the proposed district plan have been made on, and then people have submitted on that as well.
Laurie, you've got a question?
Just before the Deputy Mayor talks, taking Councillor Randall's point, what would be helpful, because we have 7 of these sessions booked or 6 more, is an email explaining your top 3 key issues of the district plan, because all your constituents vary in terms of what is of concern, and we'll try to distill that to a top 12 and provide you the difference that Tony's looking for. I think that might be useful, but I think it is so complex, and to use Sean's analogy before about everything's connected, to do the plan in a comprehensive way would be quite a feat. So perhaps if we just get the top three from all the councils, we'll be able to provide you what the evolution of that rule and that change looks like over time.
Yeah, and just if I could just say to support Councillor Matthews' commentary that you've outlined everything's joined together. It's really going to be difficult to do things without having the whole picture.
Laurie.
A very quick question. Sean's aware of some administrative, or what could be considered administrative, changes have popped up. Will they need to go through exactly the same process regardless of their size and impact?
It depends on the nature of the administrative change. So, for example, if it is a spelling mistake, there is a provision in the RMA that allows us to correct that spelling mistake. If it is a question of a change to the extent of a zone boundary or the listing of a heritage building, then that will rely upon scope, which is a subject we'll cover soon, as to how that would be changed. There is likely going to need to be a plan change process that's undertaken after the passage of the district plan. It's quite a normal thing for a council to do, which also helps clean up some of those things that have essentially changed or been overlooked during the process.
Over to you, Sean.
Very good. Nick, come forward. Yes, please.
You keep that one and I'll
Oh, yes, another one. Sorry, I make everything slightly clumsy. Yes.
So,
We will now move to public excluded.